Indiana no contact orders. Hey everyone, it's attorney Matt Crow's Marc Lopez law firm, and I want to talk today a little bit about what a no contact order is, what some of the penalties are for violating a no contact order, and what is a no, why do we see no contact orders come about in the first place? So first, what is a no contact order? It's actually pretty simple. It's exactly what it sounds like. It's a no contact order. You cannot have any contact with the protected party under any circumstance. For example, if you and this other person that's protected, let's say, have a kid together, you can't call them in order to try to arrange different child care. You can't call them, you can't text them to try to arrange different pickups. You can't call them, you can't text them, you can't write them a letter asking, hey, what are we going to do as far as drop off little Teddy or anything like that. No contact is exactly that. No contact. Indirect or direct contact. So, what does that mean? Well, direct contact is just like this. Hey, I need to talk to you. Hey, I need to go meet with you. Let's figure this out. That's direct. Calling someone on the phone, meeting someone in person, direct contact. What's indirect contact? That would be like me sending someone else in my family to go talk to a protected party. That's indirect contact. It's not coming directly from me, but it's coming from someone I know or someone else on my behalf. So, you cannot rent a plane and fly a banner over someone's house. You can't go scuba diving, write it on a cave, and take a picture, send it to someone else. No contact is exactly that. No contact whatsoever. We see no contact orders very commonly in criminal cases. In Indiana, actually, in any cases that involve anything that would be a violent crime or that results in some type of injury to another party, almost certainly is going to have some sort of no contact order associated with the actual case itself. Now, a no contact order doesn't necessarily mean no contact forever. They can be addressed at numerous different times. So for example, if it's tied to a criminal case, and most likely it'll be some type of domestic violence case, a battery case, or something to that effect, a skillful attorney will know exactly when and how a lot of these no contact orders can be addressed, because a lot of it is county specific, and even more so, some of it's even judge specific as far as when these no contact orders can be addressed. But most importantly, the protected person cannot be fearful for their life if they're around somebody else who's protected on the protective order. They can't be fearful for someone else that's also on the protective order. They need to understand that there's different avenues to go about it. So a no contact order, it is possible for that to be addressed because, let's face it, a lot of times these no contact orders are put in place at the worst possible time. It's not meant or it's not intended by the person who's actually protected. A lot of times the state just asks for it and the person protected, hey, I don't want this. I got to talk to this person. I got to write this person. I got to be able to have open communication. We live together. We're friends, so on and so forth. So a lot of times we need to make sure we go about things the right way, because if you violate a no contact order, it's an actual criminal offense. It's a new misdemeanor charge called invasion of privacy. If you have a prior invasion of privacy on the same person, it's actually elevated to a level 6 felony, which is penalized up to potentially 2.5 years in the Indiana Department of Corrections. So it's no joke to violate a no contact order, no pun intended. However, it's also very easy to allege, because a no contact order, it's a one-way street. So if I have a no contact order against you, that means I can't contact you. It has nothing to do with you contacting me. So a lot of times we see this bait and switch when let's use domestic violence case for an example. A man has a no contact order against his wife, and the wife will actually try to reach out to the husband. Hey, let's talk about little Johnny. Hey, let's talk about how we can figure this out. Let's work through this. You cannot then respond as the husband, as difficult as it is, without risking potential new charges. This is where a skilled attorney comes in to help navigate these choppy waters that are no contact orders. Because if done the right way, we could potentially get them lifted. Now, again, that's going to require some cooperation from the protected party, But if we get involved early enough, then it's possible that that person is not going to want to hold a grudge, that that person is not going to feel like they're in fear. The problem is, the more time that passes, the more potential issues with regards to that no contact order could come up. Why is that? Because the prosecutor's office is going to assign a victim's advocate to discuss with the victim exactly what happened. They're going to try to lock them into a statement that can then be used at further court hearings to potentially keep the no contact order in place, despite perhaps what they may want in that exact instance. So if you find yourself charged with any type of crime involving violence, domestic violence, battery, some cases even DUIs that involve accidents and the other party is hurt, it is imperative that you move quickly and hire an attorney with the ability to help you navigate the no contact order situation. Give us a call, 317-632-3642. And remember, always plead the fifth.